You got it. Go for it. Proceed.
All right, may it please the court, Timothy Weber here on behalf of Blake Taylor Flood. The issues in this case are the trial court's award of alimony to the wife after a marriage of moderate term duration. We contend that the wife was shortchanged on the amount as a result of the trial court's error of law in its consideration of the standard of living, as well as the trial court's arbitrary selection of a need number without adequate findings and one that was not supported by the evidence.
So you're not asking for permanent alimony? You're just contesting the amount of the durational alimony?
Our second point on appeal is we are asking for permanent alimony. We find that the trial court's findings regarding the type of alimony were inadequate. The court only said, I find that durational alimony is appropriate, made no finding that the wife would not have an ongoing need for support in this case, which I would suggest.
Well, let's talk about that briefly, because I understand the issues, but you've got a 16 or 18 page final judgment. You've got a bunch of attachments. You've got almost 100-page transcript where the court made a ruling conference. The court analyzed all the factors. Maybe there wasn't as many findings in the final judgment connecting the dots, but the purpose of the final judgment having enough detail is to enable the appellate court to have meaningful review. And having been a trial judge, I could see what this judge was thinking. Here you have a client who wanted support and maintenance based upon permanent alimony, based upon a relatively moderate marriage, had a higher burden of proof. He didn't think she showed anything about her permanent injuries or medical condition, only that she took a lot of medicine and she had issues, but she was capable of working, but we're not going to charge her with imputed income, but sure one day she'll get back on her feet and she could have some sort of a job. And then she was asking for expenses on a condo that she wasn't even living in. She's letting her daughter live in for free. She had a Texas house. She was going to get the Texas house. She had a business account. She was awarded that. And the judge says, you know, I'm going to leave it, call it a day. She's not getting anything extra other than what I'm giving her. And you could read between the lines that this was not a Goldilocks judgment by any stretch of the imagination. It was a pretty well thought out judgment, and the judge considered all the factors. So from where I'm sitting, I can see what the judge went through. And then on top of that, the party submitted a judgment and you stipulated to the entry of the judgment. Is that true or false? Not you per se, but whoever the trial lawyers were stipulated to the entry of the judge. The judge signed it. End of story. I mean, is this all correct, or am I daydreaming this?
Your Honor, had a couple lapses.
You can jump in anytime you want.
From what occurred. There's no stipulation to the judgment. Judge Meyer announced his ruling orally and asked the attorneys to accurately reduce that to writing and submit it to the court. That's a far cry from agreeing to the content of the judgment or stipulating to the judgment or waiving appellate review of that judgment. So I want to make sure that point is really clear. With respect to the rest of it, let's talk about the Texas home. Mr. Manny's argument is, hey, well, they could have deducted the condo expenses out of the standard of living and gotten to this number in some way. But that's not what happened. The trial judge understood that the Texas home was going to be sold, and the wife's standard of living was predicated on living in the Florida condominium. And so the wife was actually imputed income based upon the value of the Texas home because the court found that it was going to be sold. And so to suggest that we should disregard the condo, which was the designated standard of living and the living space that the wife was going to occupy, and say, well, she's got a home in Texas, she can do that. What happened here is the court took the testimony and said, she's going to sell the Texas home. She's going to get proceeds from that. I'm going to impute income on those proceeds. You would not do that on a homestead. And as a result of that, to disregard the condominium expenses as part of her standard of living is inconsistent with what the rest of the judgment provided for. Moreover, when you say it's not a Goldilocks judgment, where are we to discern where this $12,000 number came from that fell out of the air and was announced as the judge believed? I think this is a good starting point. The presentation, which is undisputed in the record, was what the parties' expenses were in the 12 months preceding the dissolution of marriage. And
If I may, Mr. Weber, can I interrupt you?
sure.
And I think we're all aware what the standard is and what we need to do to review. And in this case, we're dealing with the court who was the trier of fact. And I think you'll agree with me, Mr. Weber, that the court could, disregard certain testimony if he felt that it was not, competent, or he could, it's a credibility. It looks at the credibility of the parties. So my question to you, we have before us all the expenses that your client provided, which I think Mr. Manny, one of the things that he pointed to was perhaps, clothing expenses, which appeared to be like $4,700 a month. Isn't that, I'm using that as an example, that the court could disregard that testimony in order to make a determination whether or not the amount would be appropriate. So how do you reconcile the fact that the court, as a trier of fact, can disregard certain testimony that he feels he just, as a trier of fact, he just does not accept?
Well, and we have a situation where you have testimony perhaps that is disputed in a case, but this is an analysis of what the party's actual expenses were. They were just laid out and presented by the wife's forensic accountant. The husband's forensic accountant rendered no opinion on that analysis, gave no contrary information. And I would submit to the court that when you have the actual expenses of the parties in the 12 months preceding the filing of a dissolution of marriage, just saying, well, I don't believe that, is not what the court is permitted to do.
I have to beg to differ. I don't think the court actually said, I don't believe that. I think the court said it's not a super factor that you cherry picked 1 year. Sure, normally we can agree 12 months prior to the filing of the divorce is very relevant, but here they were buying Hummers, buying expensive cars, couple of $100,000 for a boat, the Texas residence, renting a luxury condo, all kinds of money, because he was making a ton of money when he's at the Spine Institute. Then he got terminated and he was sued for malpractice, of which the wife actually testified against him. He loses his job. He gets some other job. He's eventually making $75,000 a month. Well, the judge chose, I'm not picking that to establish the standard of lifetime. Those 12 months where they had this bunch of money coming in, it's just not fair. He didn't have to do that. And he explained why he didn't do it. And he cited some other cases that have different starting points with some Yankovitz, like a 28-year marriage, things like that. But you don't cite a case exactly that's going to save the day under the facts of this case. So I didn't mean to get that out.
This court's opinion in Cardio specifically says that that is the factor that a court is to consider. Now, he doesn't have to give it super factor weight, but he at least has to assess and make a finding concerning what the standard of living was.
Okay. Well, Cardio is not a good case to consider, because in that case, the court refused to consider the party's more lavish lifestyle. Here, the court considered it and rejected it. So you can't compare apples to oranges.
The court made no finding concerning what the standard of living was. It simply said, the wife presented this data and I think it's 12,000. Now, how would the court ever review that?
Let me stop you right there, because that sort of goes to the heart of what is concerning me and possibly the rest of the panel. Is the problem here that we don't have sufficient competent substantial evidence that would have supported the court's ultimate determinations? Or is the problem here that we don't have the findings on the record explaining to us how the court got to those ultimate determinations?
And Judge Rothstein Yoakum, I would submit that there's both. So when you have what is undisputed evidence concerning what the party's actual standard of living was, that went unrefuted, unquestioned, there was no contrary opinions given, and it was derived from the party's own financial records. And then when you get to the finding stage, you don't make a finding concerning what the actual standard of living is. You simply select a number of 12,000. Those are both errors. I mean, obviously anything between 0 and 23,000, one could argue is supported by the evidence if you start removing expenses. But when we don't have any findings as required in the Jukanowicz case from this court, where you're saying if you think the expenses are inflated, you got to tell us where. You got to tell us what expenses are not proven, when it's simply laid out as here is the party's own financial records of the record they created during the marriage.
So you've got a case that litigated for 7 arduous years, 7-day trial, non-consecutive. And was there a motion to reconsider the judgment to provide all these additional findings that you wanted in the judgment as opposed to in the transcript on the ruling?
With respect, Judge Meyer indicated when he made his ruling that he didn't want to do anything else on this case. He'd had enough of it. And he announced his rulings and said what they were and said reduce them to a written form and go off to the appellate court if you have a problem with them. So
is that a roundabout way of saying, no, we didn't file for reconsideration?
there was not a motion for rehearing on this specific point. But again, under the court's Engel case, that's not required.
Right.
I would like to move on to the issue of attorney's fees, because the trial court here shortchanged the wife in another significant way, and that is enforcing a prenuptial agreement on attorney's fees occurred during this dissolution of marriage case. And this was not predicated on need and ability to pay. The final judgment expressly says that. Says, I'm predicating this solely on the waiver in the agreement, and even says, you know, the wife's arguments that I should have considered this based on need and ability to pay are fully preserved for appeal. And so it's clear here that this was a reversal based solely on the terms of an agreement, which is contrary to public policy in the state of Florida. The Belcher case and the Lakshani case that describes that. And my opponent tried to slice this salami a little too thin, saying, well, the waiver of pre-dissolution fees now depends on when during the proceeding the court actually assesses them. So drew a distinction between whether it's done at a temporary hearing or in the final hearing. I would submit to the court that there's no authority for drawing that distinction. And in fact, the opinions across this state are littered with appeals from final judgments that are being reversed for lack of the ability to enforce a waiver in and of itself without consideration of any other factors. And so here, not only did that become extremely inequitable to the wife, who was put to essentially exhausting the only non-marital asset that she had to litigate this, but by a party who argued at the temporary hearing that, well, gee, she can spend down her money now because you can always adjust this at the end, and then got to the end and says, time's up. You can't even consider this anymore. And a party who through that 7 years avowedly said that he was going to go after the only money she had and make her spend it to get 1 cent. And this is a
Let me ask you a
party.
question, Mr. Weber, let me ask you this, because as you know, the analysis is need and ability to pay. Let's set aside the ability to pay. It's a question of need. And if you look at the record before us, can you let us know, or can you tell us that the former wife has a need given the assets that she ultimately received?
Absolutely, Your Honor, because the cases dealing with need don't just look solely at assets, they look at the entire financial pictures of the party. And whereas here, there's been a huge disparity in income, that has been a very significant.
Let's not talk about the disparity of income. Let's just push that aside. Let's just assume he does have the ability to pay. And you know, the case law says you can't just do it on income alone. Let's look at the actual need itself. After everything is done, and we have now the benefit of the final judgment that lays out all the stuff that she's receiving, is it your position that right now, given everything that your client now has received, has she met her burden that she is in need of those fees?
And Mr. Weber, while you answer that, keep in mind you have 4 minutes left for rebuttal, so factor that in your answer. I want to save that.
Thank you very much. Absolutely, because Florida law says that you don't have to deplete everything you receive in equitable distribution to have a need. And that is exactly what the suggestion would be here. She was actually imputed income on the little bit of investment assets she had left after paying some of her fees. But the record before the court shows charging liens filed by her attorneys, shows, as Judge Valenti mentioned, 7 years of punitive litigation with a complete failure to comply with any court orders by the husband, specifically designed to impoverish her because she made a claim for alimony against him. And then to say at the end, oh, too bad, I'm sorry you spent down what you're getting, and to say there's no need because you were able to spend down your portion of the marital estate, I would submit to the court, is not the proper way to evaluate need. And in here, had the trial court felt free to consider need and ability to pay and all of the Rosen factors, I would submit to the court that those detailed pronouncements he was making suggest that he would have awarded substantial fees to the wife. In fact, he tried to award some fees based on specific motion practice that was necessitated by the vast litigation misconduct of the husband. And I'll reserve the balance of my time.
You've got 2.5 minutes left. I'm gonna round it up to 3 since you were asked a lengthy question. Mr. Manny, you're next.
Thank you, Your Honor. One of the problems.
Mr. Manny, can I have you, Mr. Manny, address that question? Let's just pick it up where Mr. Weber finished. He's taking the position for the fees that, based on the fact that the former wife had to use her assets in the course of this, that it was really error for the court to conclude she doesn't need it anymore, she's not entitled to it, and given the factors that at least that issue was tabled until the end of the case.
Well, the question of need, of course, comes up. And we argued all along that when she received $22,000 per month for some 60 some odd months, over $1 million in support during that period, plus she also received the income from her own investments, we felt there was no question as to need. Need is really not an issue in this case. What happened, that need was a temporary issue, and it was an issue on the temporary fee. And the judge specifically reviewed the evidence that was before him and found that she had not demonstrated a need, that she had an ability to pay from her own assets any reasonable fee that might be charged on a temporary basis. But then when we got to the end of the case, the issue of need was no longer relevant so far as we were concerned, because she had entered into a contract earlier in Texas, I think years ago, in which she waived any right to the final attorney's fees. And I would disagree with Mr. Weber. I think the Hahamovich case made that distinction very clear. That is, if you sign a waiver of attorney's fees after the entry of the final judgment, if you have signed a waiver of attorney's fees, that's enforceable under Florida law. We obviously can't waive temporary fees. No one was ever disagreeing with that proposition, but the standard that was applied to not awarding her a temporary attorney's fee is different from the standard that was applied at the conclusion of the case. May I point out one thing?
And given that, Mr. Manny, how about what Mr. Weber said, that in the middle of this case, that issue, we'll deal with that later, that somehow she was lulled in waiting till the end of this and now is in a position, it's almost like, let's wait, oops, got you type of tactic.
Okay.
How do you respond to that?
Very easily. What he didn't mention was that in the order entered by the trial judge below, the trial judge specifically said he was only entering the order to be operative at this time, and that the wife was free at any time after that to file a motion to modify. That's provided in the final judgment. And that's the correct statement of the law, that if her needs change, she was sure free to come in there. Now, she couldn't do that because she was getting $22,000 a month from the husband. Plus, as it turned out, she wasn't reporting any tax liability with respect to her own income from the other assets. She received over $1.25 million during this period of time. She never could come in. And I would submit to you, she properly did not apply for a modification of the temporary order. And she could have, but chose not to do so because she knew she couldn't successfully advance that proposition. She was very well.
I'm sorry, Mr. Meany, wasn't there evidence in the record that she was taking out loans at this time against her investment account in order to meet her expenses?
There were, and she didn't ever apply for any modification based on that basis. I think she could have, and then I would have been glad to deal with that at the time, but she never did apply for any change. That's because she was also receiving $22,000 a month. And she was not using that $22,000 a month the way she originally said she was. That money was paid to her based on a condo expense of some $8,500 a month. That was and $4,500 a month for clothing and $2,000 a month for gifts. She wasn't spending that money that way. She admitted that because she was sick or was feigning illness in our position, that she couldn't possibly have done that because she was just sitting at home all the time. I'm not throwing rocks, but the judge listened to this case for 7 years. 7 years, and she filed over 7,000 tweets against her husband, who was constrained to file an action for defamation against her, which eventually went away. But she was also consulted to write a book about her experiences. I won't go into what the record would reflect as to who was in the courtroom with her during the period of the trial, but very rarely will you see a judgment as carefully reasoned as this one was. I would agree with everything that Judge Valenti said with respect to the care that this trial judge applied to the dispositions of some very difficult issues that were presented to him. Counsel for both sides was competent, and I'm not saying that any of the lawyers, all of the lawyers did a good job in this case, and they all did it. One of the things that didn't appear immediately with respect to Judge Valenti's question as to whether or not a motion for rehearing was filed is both parties opted not to file a motion for rehearing because of the care that the judge had given to his determination in this case. He invited each side to submit the arguments with respect to proposed final judgment, whether they approved or disapproved of the form of the final judgment. Each party was given the opportunity to prepare a memorandum of law with respect to each provision of the final judgment. That final judgment was crafted not only by the trial judge, but by all the lawyers involved. All the lawyers knew what the arguments were, and the trial judge selected what he thought was the appropriate argument. What's now before the court is not what was before the court below. If I may, Your Honor, go back just to a point, and I just want to respond very briefly. Yes, the trial judge had before him testimony with respect to the expenses of the wife. The first affidavit the wife filed was an affidavit filed way back at the very beginning of the case. The last affidavit she filed was one filed in 1968. And of course, the case was tried was, I said 68, 2018. Under those circumstances, that was evidence before the court of her need. She admitted in testimony that she was not incurring two of those expenses. She said, I'm not incurring the condo expense. I'm living in a Texas household. She opted not to sell it, something she had the right to do, but chose not to do. She also said, I'm not paying out that $4,000 a month for clothing. She could have, but she wasn't. She was not spending all the money that she had originally spent to justify what she was saying. So there was evidence before the court, and the judge was entitled to review that affidavit and determine what was appropriate in the affidavit and what was not. Now, the pertinent question that might be asked was whether or not the judge is, as a matter of law, required to isolate those items that he is not accepting in connection with the determination of her alimony. I offered a proposition that all you had to do was eliminate consideration of the condo expense, eliminate consideration of the clothing, and then put in the consideration of gifts. That's the $12,000 a month. She got exactly what she asked for, less the option for gifts. That was not mentioned by that. I put that in there. That's true. But she herself was the one that eliminated consideration for the condo expense and eliminated consideration of her clothing expense. I say to you, she had claimed $96,000 a year for the condo expense, and she had claimed 40-some thousand dollars a year for her clothing expense. That's $130,000 a year. I must admit, I thought that was outrageous, and so too did the judge. He refused to accept those, and he explained why. She said she wasn't using her clothing anymore. She said she wasn't using the condo anymore. Now, the point that Judge Valenti made, though, which is the most significant point from the overall perspective, is this man made more money in that 1 year than he had ever made in his life. And unfortunately, the wife opted to testify against him in a malpractice action that had been brought against him and his employer. And although the employer would not ever admit the reason that he was terminated shortly after that event. So in a way, there's a proposition that the wife is responsible for the termination of the husband's employment. I'd like to move on, if I may, for just a moment, because I think the evidence was more than ample to support the proposition that she got everything she was entitled to. But she did something else. And it's what she didn't do that got the husband in trouble. In the judge's original order, he made no determination as to whether or not the taxability of the temporary support. At that time, when he entered the initial order, it was still appropriate for the husband to have deducted the payments that were being made to the wife as ordinary deductions from his gross income. And he did so. There was nothing in the order that prohibited him from doing so. Later on, when the wife received a letter from the IRS, then the husband was made aware of that fact. The court eventually entered an order requiring the husband to file amended returns. And that's what he did. He said, I want you to file amended returns. Your Honor, he violated Rule
Here's
1.
Mr. Maney,
Yes, ma'am.
what was the basis of the court's ruling with respect to that? Do we know why the
Yes, the wife said, I've been audited, and brought her accountant in and testified. And the accountant for the wife testified that she had entered into some sort of agreement with the Treasury. We don't know what, but we do know that the court said, I'm going to make a decision now with respect to my original order where I made no determination as to the liability of the parties. I'm going to find that the husband should file an amended tax return reflecting the recent amended tax return to reflect the fact that there was no authorization for him to enter and make that deduction. Of course, there was no hearing on that point, and we tried to get a hearing, didn't get a hearing, and there was no time set for when he had to do it. And that really is a violation of Rule 1.57C. And under those circumstances, we said, well, we're not going to file anything. You haven't made any determination of how much he's got to pay.
So let me backtrack, Mr. Ring, because I know you're making an argument, basically due process, that your client was not given the opportunity to present when the wife came forward before the court. And I know it's here. I just don't want to be able to take the time to pull it up. And basically said, I've been audited. And then somebody came in and testified before the court. At that hearing, did the court at that point look at you or look at the former husband, said, okay, let us see if we could hash this whole thing? Was it?
No, ma'am, there was no opportunity. No, ma'am. I wish there had been. There was no opportunity for us to say to the court, Your Honor, we are just finding out about this. We do not believe that we have enough information to go forward. And we didn't know what the consequences were. And so as it stands right now, we do not have due process with respect to two things. One, the additional money that the husband was required to pay to the Treasury. We have no idea how much that is. We do not know what would be the penalties imposed by the Treasury. We don't know anything at all about it. He's just been required to file amended returns. Now, did he give us a date as to when that would be done? No. That's important because some of these amended returns cannot be filed because of the passage of time. This is a 7-year case. Some of the payments started being made some 8 or I guess by now 10 years ago. And the Treasury is barred by the statute of limitations with respect to some of these amounts. We do not know anything at all about how much we have to pay. That's what we refuse to follow this order because of the failure of the trial judge to say what date we had to file the amended returns. And that's the defense we have right now. And we're trying to find out, when are we going to have to file these amended returns? And moreover, when are we going to be given the opportunity to make a determination of how much we're going to have to pay? And should we be required to pay this amount? In that respect, we think the trial judge erred, and that's the point of our cross appeal.
And Mr. Maney, to the extent that there was harm, if the trial court ultimately determines there was harm to the wife, that she has been unfairly penalized by the IRS.
But she's made her deal, Your Honor. She apparently has made her deal.
I
And they've
understand.
said-
I understand that. And then if the tax liability was supposed to be on the husband to begin with,
Yes, ma'am.
would it be appropriate for the trial court to say, look, okay, maybe there was a mistake. Going forward, I want to make it clear the husband has the tax liability for these payments. Former husband has to reimburse the wife for whatever deal that she made with the IRS. You know, rather than requiring, because my understanding is that the maid, apart from the due process issue, the main complaint is having to go back and refile these tax returns with the IRS, which the IRS has never requested. Could the same thing effectively be accomplished by simply requiring the former husband to reimburse the former wife for whatever penalties or whatever she's been assessed, and then going forward saying, you know, former husband, include this in your tax returns?
Yes, ma'am, you could do that.
Okay.
Yeah, that's a lesser included, and you certainly could do that. And see, we never had the chance to present all that to the trial judge, and I would like to have done that. That's what I primarily did was tax law, and I was very concerned about this because I recognized that the imposition of this amount, $1.25 million of payments, could be very substantial on the husband, and there's no showing of his ability to make those payments anymore.
Let me ask you one question. Wasn't it correct that the judge put everybody on notice on not dealing with the issue of assignability of the tax deduction? He left it open, which means either side could have come in and said, Judge, we need you to give us an answer to this tax thing, but they took it upon themselves either not to file a tax return or to take a deduction, never got court approval. So this is kind of almost in the nature of contempt. The judge fashioned a remedy, whether it's subject to change or some other motion in the future, I don't know, but I'm not sure you need a signal from this court. And also is a pretty important factor that the judge considered in awarding alimony to the wife, that she didn't have to pay.
In paying taxes, that's correct. You're absolutely correct.
So we'd be on doing a whole bunch of stuff if we opened up a can of worms on this tax issue.
Yes, sir, you can. The only thing we'd have to say, and the real reason we made the argument, is give us a date by which this will be done, and we'll deal with the IRS.
Well, that might still be on the table. We don't know. The court didn't provide a date.
I understand, Your Honor. That's what we said. That's one of the basis of our argument. The court did not provide a date, and the rule specifically provides he has to give us a date to do this by. We haven't done it. And the reason we haven't done it, bluntly speaking, is time passes, and the statute of limitations is going to bar the argument.
I understand the argument. Okay.
Thank you, Your Honor. Thank you very much, Your Honor.
All right. Thank you. You didn't use all your time up, but I did give Mr. Weber up to another 3 minutes if he needs it.
All right, thank you, Your Honor. Just quickly on the tax issue, I want to read from the final judgment. It says, the husband shall file such amended tax returns as may be necessary or appropriate to reflect this ruling. And so it left it up to the husband to file the appropriate tax returns to reflect the non-taxability of support. It didn't say you must file 2013 or you must file 2014.
So you agree with Mr. Manny's argument that this is still an open issue?
Well, I would agree with Mr. Manny's extra record statements about what has occurred since the final judgment, that his client has not complied with any of these provisions, has not filed amended returns.
Well, that's not before, so we can't consider outside the record.
That's what he was telling us a moment ago. And so, yes, this was in the nature of a contempt remedy because the husband intentionally took these deductions to impose a tax penalty on his wife during the dissolution proceedings.
But you agree with the observation that this could have gone the other way. The wife also took it upon herself not to file a tax return to report no income because she didn't know if she'd be required to be charged with the income. So both sides did a calculated risk here. And therefore,
the wife would not be obligated to file a return because she had no other income.
Well, I'm not sure if it gone. Yeah, I was not hypothetically had it gone a different way where the judge says you have to pay taxes on this income now and you file the amended returns, but it didn't happen that way. So both
Right.
sides took a chance. That was my point.
Two other quick points here. We talked about, oh, well, there's all this careful crafting of the attorneys in this judgment. No, Judge Meyer had a few things that he wanted the attorneys to address post his announcement of his rulings, and they each submitted briefs on those specific issues. It wasn't a invitation to rebrief every issue in the case that he had finally settled in his ruling. And then finally, with respect to the close and the condo expenses and that sort of thing, the husband acts as if he was paying his support during these proceedings. There was $257,000 in retro support in the final judgment, and there were multiple contempt motions throughout this where he wasn't paying the support for years at a time. And now he's saying, oh, well, see, when I wasn't paying you the money, you were not incurring the expenses that we had ordinarily and customarily incurred during the marriage. And that is exactly what the wife's forensic accountant testified, that sometimes the parties' actual expenses during dissolution proceedings are based upon the amount of temporary support awarded or an imposed budget by, in this case, a non-payer. And so I would submit to the court that that's why the law says we look at the 12 months preceding the dissolution. What did the parties do when there was an intact marriage? I would ask the court to reverse the findings on alimony and specifically to reverse the trial judge's refusal to consider need and ability to pay on attorney's fees. He did not consider need in this final judgment. He said, I'm not considering it because of the waiver.
All right, you have used up all your time plus the extra time I've allowed you. So I want to thank both sides. As always, you did a terrific job, and we're going to be adjourned. So have a nice day, everybody.